Hello and welcome to the FedNexus Law Government Contracts Industry Report for the week of October 27th. I'm Jennifer Aubel. In our in-depth section this week, Kevin, Joyce, and I will be discussing a recent SBA size appeal decision that creates a virtual black hole around the ability of contractors to file size protests regarding GSA blanket purchase agreements that are set aside for small businesses. But before we get to that, here are the federal contracting news headlines for this week. A quick reminder to all our government contractor listeners out there that October 30th is a significant reporting deadline for a number of different contract requirements. GSA schedule holders are required to report their sales and remit the IFF via the 72A system. Large businesses need to file their individual and summary subcontract reports at ESRS. And service contractors should be aware of a new requirement under FAR 52204-15 that requires them to report all of their service contracts with values in excess of $150,000 on SAM.gov no later than October 31st. In strategic sourcing news, GSA announced today that the JanSan Purchasing Channel strategic sourcing vehicle is now open to orders. Agencies wishing to place orders against the JanSan Purchasing Channel currently need to contact BPA holders directly, as integration of the BPAs with GSA Advantage and DoD EMAL has not yet been completed. Finally, GSA released a few statistics regarding the performance of its reverse auctions platform in fiscal year 14. According to GSA, 85% of all the awards through the reverse auction platform went to small businesses, and the reverse auctions generated savings of approximately 23% off of standard contract prices. Perhaps in a dig at FedBid, GSA also points out in its infographic that there are no fees associated with its reverse auction platform. And now we're moving on to our in-depth section of the broadcast. Here in the studio is Kevin Joyce, an attorney with FedNexus Law, to talk about a recent blog posting on FedNexus Insight. So Kevin, in your blog, you talked about a recent size appeal decision from the SBA Office of Hearings and Appeals. And you found that this decision could be very impactful for companies that are bidding on blanket purchase agreements against the GSA schedules. So could you tell us a little bit more about the case and how it's going to impact contractors?
Sure, Jennifer. First off, thanks for having me on. Happy to be here. So in the recent case, size appeal of Total Systems Technologies, the question was raised before SBA's OHA as to when the proper time for a challenge of a BPA would be under 13 CFR. Normally, under a small business procurement for a negotiated procurement, you would have a size status challenge come in at the time of the initial offer, including price. In other words, the challenge would be based on the size status of the offeror at the time that they submitted their proposal. Now, the interesting thing about this particular case is this was dealing with a blanket purchase agreement, and there is some confusion within industry as to exactly when the proper time to challenge the size status of an offer under a BPA award is. To make it even more confusing, this case dealt with a federal supply schedule contract, in other words, a General Services Administration contract. And as we're all aware, that is a multi-year contract, which is actually known as a long-term contract. And this is significant because in order to challenge a long-term contract under 13 CFR, there are specific times that differ from when you would challenge an award under a negotiated procurement or a procurement not for a long-term contract. And so if I didn't confuse you there, I'll try and confuse you a little bit more. There are 3 times when the challenge under a long-term contract can occur. And that's the time of the initial award of that long-term contract, upon any type of option renewal under the contract, and finally at the time of award of a task or delivery order under a long-term contract where the contracting officer expressly requests recertification upon the submission of the offer for that task or delivery order. So I talk about the black hole, and what I really mean about this black hole is essentially there is a gap or a time frame where a small business awardee under a GSA contract can actually certify at the initial offer that they are in fact small, and can continue to get awards even after possibly becoming a large business, unless they are in fact asked to recertify upon the issuance of task or delivery order contracts during that first 5-year term, or actually during any 5-year term. So essentially, the situation you have here is you may have an award of your initial GSA contract, and then you are not really going to have to recertify until the award, or the option exercise, which is 5 years after your initial award. So unless you have a task or delivery order award where the CO actually does in fact request recertification, you could have a long period of time where an other than small business does in fact receive small business awards. So in Size Appeal of Total Systems, OHA actually looked into the regulatory history surrounding when the proper time frame was for an appeal of size status regarding an FSS contract, and it turns out that SBA's regulatory process actually reviewed this situation some time ago and made a recent regulatory revision that actually provided that contractors would have to certify on BPA awards at the time of submissions of their offers, including price, which is in line with when an offer would actually in fact submit their size normally for a negotiated procurement, otherwise for not a long-term contract. I should go back. I think I got ahead of myself here, but a long-term contract is in fact a contract which has a duration of longer than 5 years, including options, which is why GSA contracts do in fact constitute long-term contracts. The confusion, as I keep getting back to this confusion, is with BPAs. BPAs are agreements. They are not considered separate procurements. As we know, BPAs are issued pursuant to GSA contracts, and when you actually do submit an offer for a BPA, technically there is no time or no requirement, I should say, for a contractor to certify their size status at the time of submitting an offer for a BPA. SBA regulation has been revised to actually provide for a closing of the loophole somewhat, and the loophole, of course, is the BPA submission. So now SBA regulation provides that on or after December 31st, with respect to agreements, and those agreements include blanket purchase agreements, a concern must qualify as small at the time of its initial offer for that BPA, which includes price for the agreement. So when you read that, it sounds very, very good because it sounds like they've closed the loophole, but actually when you continue reading, you find out that the regulation has actually carved out BPAs that are issued against GSA scheduled contracts. So there's new language that really does say, except for BPAs issued against a GSA scheduled contract. Now, it's very odd that this would be an enumerated exception, because it seems like SBA got 95% of the way there and then slammed on the brakes right before they brought it across the finish line. If you look at the preamble to the regulatory history in the Federal Register, this issue was actually addressed and brought up in the rulemaking comment period. And in fact, SBA came out and said that they did think it was unnecessary and burdensome to require offerers to certify their size at the time of a BPA award issued pursuant to a GSA scheduled contract. And their reasoning was a little interesting. They essentially said that because there already had been a determination of size at the GSA scheduled contract award, that it was going to be overly burdensome for the contractors to certify their size at the BPA award itself. So oddly enough, they're saying that it's not necessary for you to certify your size under a GSA BPA. However, they found it necessary to close the loophole on all other BPAs that are issued, which raises the question, what really was the reasoning for imposing that burden on offerers for BPAs under long-term contracts, but not GSA BPAs under similarly situated GSA long-term contracts? And so really now we are left with a black hole. That's where the black hole comes into play, because now if you are an offerer who wants to challenge if you are a protester who is interested in challenging the award of an offerer who you believe is submitting task order submissions or delivery order submissions under a GSA BPA, you are not able to actually challenge any of the task order or delivery order awards of the BPA unless the contracting officer expressly asks for recertification. And I will say, curiously enough, if you look at some of the other cases under OHA that actually came out after the decision in size appeal of total systems, you'll find that in order to expressly request recertification, the contracting officer really must go above and beyond what you would expect an express recertification to include. In other words, even if the actual offerer checks a box or writes in their offer that they are in fact small and are in fact a member of some socioeconomic subset, that actually does not constitute a recertification. So the contracting officer must expressly request the recertification, and it leads you to believe that there must be some type of magic words or some very, very, very specific language that needs to be in that actual solicitation requesting the recertification. So you may be asking yourself, okay, I hear all of this. What's the big deal? What really is the impact? And the impact is there's been a very, very close scrutiny of small business contracting within the federal government across all programs, and especially in light of all of the FSSI, the Federal Strategic Sourcing Initiative contracts being put in place. Small business is looking and saying, we are essentially being pushed out of our own niche environment, our own industry. And this ruling in Total Systems essentially creates another obstacle for small business, because now small business is not only going to have to worry about all of the contract consolidation under FSSI, but they're also going to have to worry about large businesses possibly getting awards under FSS BPAs when they really shouldn't be getting those awards. And the small business regulations do not allow for any type of challenge at this point unless the contracting officer essentially allows for it on a task order or delivery order. Now, of course, remember, you can still challenge the underlying GSA schedule contract, but as I mentioned, you're only going to be able to challenge that essentially every 5 years. So you may have a 5-year period where you have a competitor who does in fact become large shortly after their award or shortly after their option renewal, and unless the task order or delivery order contracting officers issuing the awards to them expressly request recertification, you will not as an unsuccessful offerer be able to challenge the size status of that awardee. And therein lies the problem. So as of now, there is a black hole that GSA BPAs occupy, and until further notice, there's not much that small businesses can really do about it.
Well, it's interesting to hear it from the contractor's perspective, the legal perspective of what options contractors have, because I've definitely seen this issue from the GSA perspective, and GSA really touts this as one of the benefits of the schedule program, is this loophole that you can be small the day your contract is signed, become large the very next day, and just ride that small business status for the next 5 years. So, they probably don't put it like that, but essentially that's what they're saying. And the same thing with like 8A. Your 8A is going to be expired, and so you can keep going with your 8A as long as they don't ask you to recertify. But I want to go back to what you were saying about strategic sourcing, because I think there's a real overlap there, and that's the large majority of these strategic sourcing vehicles are BPAs.
That's right.
And so it's almost like a double whammy there, because if I'm understanding what you're saying about this case, then these BPAs are not eligible for size appeal for strategic sourcing.
That's correct.
And these are potentially multi-billion-dollar blanket purchase agreements that are really winnowing down the number of eligible contractors in the market. So it's really interesting that you don't have any recourse there to challenge based on size.
Right. So remember, BPAs, you can challenge a BPA on a long-term contract, but they have exclusively cut out those BPAs that are GSA schedule contract BPAs. So for instance, there have been FSSI BPAs that have been issued pursuant to GSA contracts. Mm-hmm. And as you aptly put it, that is an exception now that is hitting small business contractors twice, essentially, because they are now facing challenges with FSSI in general, but specifically they're facing even more challenges with FSSI BPAs under GSA schedule contracts. And as Jen, I know you're aware, there have been several protests unrelated to size on some of the FSSI BPAs. And it's interesting to find that the FSSI BPAs under GSA schedule contracts are in fact accepted from any size status challenge at the award of the BPA. So, it's an odd caveat that SBA has elected to implement, and it does create a situation where it's almost a double standard, because you have to ask the question, why would a BPA be properly challengeable under a long-term contract?
Everything else.
That is not a GSA schedule contract, and the answer was essentially administrative.
It's too
burdening.
hard.
Right, too hard for contractors.
It's too hard for them.
Maybe there are other reasons. I'm sure there are, but as of now, that's the reason that's been given by SBA, and OHA has interpreted the regulations and has interpreted them in the favor of SBA's rulemaking. So until we see another case before OHA, that is where we stand, and that's how the landscape will remain until we're otherwise told.
Wow. Well, thank you so much for coming in and talking about this issue. I know it's going to impact a lot of small businesses and pseudo-small businesses out there, so thank you very much for coming in today. And that wraps up the GovCon Industry Report for this week. I'm Jennifer Allbell. We'll see you next time.